Hello, my name is Currie. I'm the Senior Research Fellow at the Canadian Forum on Civil Justice. I've been asked to talk with you today about a paradigm shift occurring in how we think about access to justice. Wish I could be with you in person, but I am fortunate to be able to have this opportunity to talk with you. Um, Before talking to you about the paradigm shift, I'd like to talk briefly about another idea that's very much related to access to justice and to, the paradigm shift idea, and that's about wicked problems. Now, a wicked problem is a term in the public policy literature uh, that refers to problems that are inherently resistant to resolution, that are very, very difficult to resolve or to make progress on because of the characteristics of the problems themselves. Now, a few of the characteristics of wicked problems are, one, that they're very difficult to define. Second, wicked problems are very complex. They have many interconnected parts that are often conflicting. Um, Third, the responsibility for the different parts often lies in different organizations and makes coordination very difficult. Now, I guess that's beginning to sound a little bit like access to justice, um, is it not? Um, Now, another characteristic of wicked problems is that the concepts and the definitions and the empirical facts that frame the problem and the questions we ask about it are constantly changing. The problem, in a sense, becomes a moving target, and it's very, very difficult to make policy decisions about the problem, because things are changing, so rapidly. Now, I think that's what's occurring in access to justice, and that's what we mean by a paradigm. Uh, for me, a paradigm is a body of propositions and concepts and definitions and empirical facts that give you an overall view of the problem, that guide the questions we ask about it, and move us in certain directions towards solutions to that problem. Um, and there's where the paradigm shift is really important, and how it relates to wicked problems is that we have to know the kind of problem we're dealing with in order to make any progress toward resolving it. And we have to know something about the paradigm that's emerging. Otherwise, we just simply don't know, you know, what the concept of the problem is evolving into. Now, in access to justice, to move to the paradigm shift, in access to justice, we're moving from a perspective or a paradigm that has focused primarily on the courts and lawyers, on the formal justice system, towards something else. I'm sure I'm not telling you anything you haven't heard many times before, that we're moving from a concept of a legal problem that's limited to the very complex problems that require lawyers and are adjudicated in the courts to something much, much broader. Now, but I think part of the problem in dealing with the paradigm shift is that we have to recognize that the traditional concept or paradigm of access to justice, involving lawyers and courts and very complicated, difficult legal problems, that's still prevalent in the popular culture. That's the way most people think about legal problems and justice. And, in fact, I think that, that is still the predominant view of a great many people in the justice system. Um, the competing paradigm that's emerging away from the system-centered paradigm is often called the everyday problems paradigm. Now, this is not entirely new. I mean, I think that some of the basic ideas can be found in the literature, the access to justice literature, about access to justice requiring more than lawyers to resolve these complicated problems. Goes way back to the early days of the access to justice movement in the United States in the 1960s, when the when legal aid was part of the Office of Economic Opportunity. It was war on poverty for people among you who have long memories or know the history. Um, but the new paradigm, you can find the similar ideas way back in the access to justice literature, but the new paradigm really began to take clear shape with the legal problems research that began to emerge in the late 1990s. And again, this is a body of knowledge that I think that most people are now quite familiar with, and I imagine most of you are quite familiar with. Um, the origins of this body of research uh, were in the discussions in the 1990s of civil justice reform, when when some researchers who were part of the discussion uh, observed that the discussion of civil justice reform was going on without really knowing uh, the about the legal problems that were experienced by the public. And further, they observed that you can't understand legal problems experienced by the public by looking at what happens at the tip of the iceberg, which is the courts. You have to do something quite different. So they started doing surveys of self-reported legal problems, asking some very basic questions. What are the problems that the public are being experienced by members of the public? What do people do about them? Uh, do they get the help they need? And what happens when they don't get the help they need? And the questions were the questions on which the research was based, the surveys were based, were very carefully designed to make sure that the questions or the problem scenarios had legal content. Um, there were no assumptions made that people would necessarily understand the legal aspects of the problems that they were experiencing, and it was assumed that people could do all sorts of things, take all sorts of steps to resolve problems other than going to the formal justice system. Now, the defining character of this body of research, this method, was that you have to look at legal problems from the point of view of the people experiencing those problems and not from the point of view of the system. That body of research began producing a quite remarkable body of research results. Again, I think this is something that you're very familiar with in general, so I won't talk about them in detail. Just briefly, some of the very basic findings that began to define this, new way of looking at justice and access to justice. Um, the research found in different countries, different times, in different places, done at different places, done in different places, that about a third to a half of all adults experienced one or more legal problems within some fairly short period of time, a couple of years or 3 to 5 years. Um, Very few people resort to the formal justice system to resolve legal problems that they consider to be serious and difficult to resolve. Most people do something to try to resolve them, but they take all sorts of other approaches. To put it a little differently, there are many paths to justice other than the formal system. Unfortunately, finally, I guess, um, the attempts that people make to resolve legal problems often don't work very well. When you ask people in surveys, Uh, People with problems that are resolved say quite frequently that the outcome was unfair. People whose problems are not yet resolved say the situation is getting worse. Again, people with problems that are resolved will often say that they didn't get nearly what they had expected from the resolution. So, sorry. Um, this body of knowledge is evolving into what we now often refer to as the everyday problems paradigm. Um, there are a great many aspects to this, but I'm going to emphasize two. One is that a legal problem does not begin when a court document is filed or when a lawyer takes charge or begins to work on an issue. A problem is no less legal when it first emerges in a person's life. The second thing that I think that's really a really important pillar of the everyday problems paradigm is that experiencing a legal problem is a human process. That the costs and the consequences are measured not only in money and not only in legal consequences, but in human terms, in a whole range of ways. Um, Now, what this tells us in terms of dealing with access to justice, expanding access to justice, and trying to address the legal problems that people experience, is that one thing that's extremely important is early intervention. In order to avoid problems becoming more complex and difficult and requiring complicated and expensive legal resolutions, we need to intervene early. This is what was proposed in the Action Committee's report, the early resolution services sector, an idea that was developed by the Prevention, Triage, and Referral Working Group. Um, Another one of the major implications is that we have to develop holistic approaches, and that has to be done in terms of developing partnerships between legal services providers and a whole range of other service providers to deal with the interlocking, the interconnected legal and non-legal aspects of problems, the way that people experience them in their day-to-day lives. Otherwise, the danger is that we will fail to develop effective and durable solutions to people's problems, and to do it in a timely way to avoid uh, some of the costs, both in terms of money and human adversity in people's lives. Uh, Thank you very much for the opportunity to talk with you about something that I think is very important. Hope you found it useful. I wish I wish I were there with you to be part of the discussion. So thanks a lot. Bye for now.